everyone, welcome back this week to our Legal Talk. My name is Alicia Cusack, and this week I'm joined by our new candidate attorney, Hofi Mohari. So Hofi Mohari is currently doing her rotation through our Labour Law Department, and that is why we've invited her to come and do her first podcast. So the issue that we'd like to discuss is obviously labour related, and it is a question that was sent to us by a listener, in fact. So it is a bit of a controversial topic, I think, but we are going to try and address it as best we can. So basically what it is about is gender expression, right? So it has been a hot topic for a while. It is a new development, but what this person emailed us about is they were born as a male and they've recently decided to start identifying as a female. So they've been at their place of employment for a while. Obviously, they have always known this person to be a male and look like a male. And now all of a sudden, they want to start expressing themselves as a female. And they feel like they have been facing repercussions because of this decision. So they want to know, can their boss decide to fire them because they've changed their gender identity? Or, essentially, is that something they should be scared of at this stage?
Absolutely not. That would literally amount to unfair discrimination and an unfair dismissal. So we actually have two issues in one in this instance, because with the Labour Relations Act and the Employment Equity Act deals with them as two separate issues. However, they can
being now two separate issues, being dismissal and discrimination. Okay.
Yes, but you cannot be unfairly discriminated against in the workplace.
Okay.
Neither can you be unfairly dismissed. So that would amount to unfair dismissal based on unfair discrimination.
Yeah.
Because it would not affect. It would really depend on whether or not this change that they have underwent has affected their inherent job requirements, or whether or not it was for purposes of taking on affirmative action, which mean including or trying to achieve employment equity or representation by including designated groups.
So you mean like, unless the fact that they've changed their gender identity means that they are no longer able to do their job, in simple terms, that should not be something that they can be dismissed for?
No, they cannot be dismissed for changing the gender or sex.
Yeah.
And
unless they can't do their job anymore. So I think
unless they can't
an easy example is if you're a physical laborer and you were previously a male, you've gone through maybe gender reassignment and hormonal treatment, and you're no longer able to physically do the work you were previously able to do. Maybe then your employer could have grounds for considering your dismissal. But as long as you're able to do your job, it really doesn't matter whether you show up as John or Jane.
No, it shouldn't matter. Because obviously if you are unable to do your job, that would amount to incapacity.
Yes.
So,
and then that's actually what the issue is. The issue isn't you're changing gender. The issue is you can't do your job. And then you refer to like affirmative action, because we often hear the thing about BE, and I mean, it's still unfortunately quite controversial and things, but BE is discrimination, right? Because I am choosing certain persons because of their race, because of their gender, because they are disabled, but it is a fair form of discrimination, right? So I am allowed to do that.
You are definitely allowed. With affirmative action, you must obviously be able to prove that you took a certain group of people, and for this particular reason. It must still, even when taking on affirmative action, the standard should not be compromised nonetheless. So they must still meet the requirements of the job.
So I can't just say, let's say I'm looking for a post as an engineer and I only have males with engineering degrees applying for the post. I can't then appoint a female with a law degree in the post because, yes, she's a female, but no, she doesn't have the necessary skills to do the job. So that would again make it unfair.
Yes.
So there's actually a lot of factors that the employer has to take into consideration when they're making these types of decisions.
Yes.
So if I then now find, okay, you aren't able to do your job anymore, you know, whatever the case may be, can I just dismiss you at the drop of a hat? Because a very interesting story we have been told is of a cashier who was seen stealing money by her employer. And then he walked up to her and he said, dismissed, you're stealing money from our company. And she took the employer to the CCMA and she won. Because the CCMA said, yeah, she stole, okay, but you were supposed to follow procedure before dismissing her.
Procedural correctness or fairness is very important in this instance. There are internal procedures that one should follow, and it's very important that the employer is very cognizant of this, because even if you are substantively correct, you can be procedurally incorrect. And so procedural fairness or correctness would amount to maybe internal procedures that one has to follow, notices, the amount of days for the notices, and trying to resolve the dispute internally within the workplace.
And those like notices and time frames and whatever, is that prescribed by law? Like there's a law that says so many days this has to happen, blah, blah, blah. Or do I, as an employer, decide I'm only going to give you 24 hours notice of a hearing? Like, is there somewhere some law that employers have to comply with?
Ultimately, there is a law because the basis of labor law is regulated by the Labor Relations Act. But there are policies within the workplace that regulate for that specific workplace. So to a large extent, it's to the discretion of the employer based on policies, policies that they have implemented.
Okay. And so let's say again, okay, there's valid grounds or not valid grounds rather for me to be dismissed. My employer has now dismissed me. What do I do about that? Generally, obviously, when there's a legal issue at hand, people have to go to an attorney. Is this also something where the only thing you can do is go to an attorney? Because I mean, we all know about the CCMA. But I think even myself, I don't always know, is that like a self-help court or do I still have an attorney come with me and represent me there?
Okay, so the CCMA is a body that was established for purposes of helping employees. It is a cheaper or it is an alternative method of resolving dispute other than the labor court or litigation. So it's accessible to everyone, and that was, I think, the idea behind it. And obviously, initially, you will start by attempting to write a grievance to your boss. If that internal procedure fails you, then you will approach the CCMA by referring the matter or the complaint with the CCMA to try and resolve it by methods of conciliation or arbitration or however far the matter gets.
And then how does that work? Do I just show up at the CCMA like it's home affairs, sit in a queue, get the form? Where do I start this process?
There are forms that one can get to refer the matter to the CCMA. It's actually called a referral form, also known as a Form 7.1 or 7.11. With that form, you lodge your complaint to the CCMA, and you can find it at the CCMA offices or on their website, or if not on the website, you can also find it at the Labour Department.
Okay, great. Well, if it's on the website, we will be linking to it down below. So you can just go into the description. We'll link to the CCMA's website where you can find those forms and any other guidelines that they have about referring a dispute to them. So you've now referred to conciliation, which I assume is one of the C's in CCMA, and then other processes that you can follow. If I need an attorney, so let's say it's a difficult matter for me, I don't feel sure about what to do, can I have an attorney go with me?
you can't have, there are certain rules that the CCMA has put in place with regards to legal representation. So for a process such as conciliation, you're not allowed to have legal representation because the whole idea behind it is that it must be an informal dispute resolution process between the parties, and at most a trade union representative can come.
Because I guess on the one hand, you might have an employee who really wants an attorney to help them because they don't feel sure about the situation. But obviously, having an attorney isn't a cheap solution to any problem ever. So that might be a difficulty for you. And then vice versa, I guess if you're dealing with really big companies or corporations, the concern might also be that the employer shows up with a fleet of attorneys where the employee isn't even able to afford an attorney, and then it kind of leads to a bit of injustice if there's no rules regulating representation. So if I've gone through conciliation and I assume there's a third party that makes a decision, right? Kind of like a judge, or what are they?
Commissioner.
The commissioner. Okay, so let's say the commissioner has now made a decision. Yes, it was unfair. No, it wasn't unfair. Is that the end of a story? Is that like a court judgment, or what happens after that?
Because conciliation is informal, the decision is not binding on the parties.
Okay.
So the parties can pursue the dispute further if need be, or if they want to. If there is a certificate that the commissioner will issue out, and after issuing out that certificate, whether it was successful or unsuccessful, a party can refer the matter for arbitration.
Okay.
And arbitration is the more formal procedure, and the decision by the commissioner is binding on the parties.
In the case of arbitration.
Yes.
Okay.
Another important thing to also note is that with arbitration, legal representation is allowed.
Okay.
However, there are rules for legal representation within the arbitration process. So with legal representation, it's to the discretion of the commissioner at the request of the party.
Okay.
It can also be by agreement between the parties, and if parties don't agree, one can apply and the other party can oppose.
Okay.
The commissioner will ultimately make a
So
decision.
if the employee says, I want an attorney, the boss or the employer might have an opportunity to say, no, we don't consent. And then we bring an application to the commissioner, and they will ultimately then decide whether legal representation is allowed or not. So after this, I presume the only further thing that you could do is to go to court, right? Is there a specialized court that you go to? Because, I mean, everyone might not be aware, but we've got quite a few courts in South Africa. Do you go to a normal court? Does it have to be a high court? How does that work?
If arbitration fails, the next logical step is to refer the matter to the labor court.
Okay.
So you would take, because it is a labor dispute, so you would refer the matter to the labor court.
And then what is the relief that I seek? Because I recently had a matter, or a consultation rather, where this person was dismissed from their job, right? And the ironic thing about their dismissal wasn't that they were upset with their dismissal. It was that everyone around them was upset about the dismissal. So the people who had worked with this person told them to go and see an attorney because they wanted him to have his job back. So we spoke about it, and he ultimately said to me, listen, he doesn't want his job back. Firstly, he was lucky enough to get another job very soon after the dismissal. And secondly, he said, these people have now dismissed me, right? They made allegations about me. These allegations, in my opinion, aren't true. But now there's a bit of a story walking around about me. Do I really want to go back and work with these people? And ultimately he said no. He doesn't want to go back and work with them. He has another job. He's quite happy. So I think that issue about not wanting to go back to your workplace probably happens more often than not in the case of dismissals. So is that all the CCMA does? Do you have to ask for your job back, or can you ask for money instead of your job back? What do you do?
Absolutely. Reinstatement is not the only recourse that one has you can ask for compensation. That is the other remedy that is afforded to the parties who are available to the parties.
And is there a method for calculating this compensation that you should be entitled to, or is it, is it like salary based or is it damages based? Do you know how that distinction is made?
I would assume that it would be based on your salary. It would be based somewhat on your salary and the amount of damages that you have suffered.
Because as a result of me being dismissed, I haven't earned an income maybe for X, Y, or Z months, whatever, and then on the basis of that, they would give me a certain amount of money to compensate.
So whatever the amount that you claim, you should be able to obviously
substantiate why I want that amount, of course. Okay, and then I know, so my experience is very much limited to a sense to civil litigation. So when we have clients come and consult with us, a common thing that we hear is, I paid someone money or whatever the case may be and I want the money back. And then the first question is always, when? When did that happen? Because for civil claims, you only have 3 years within which to claim your money back. So that's maybe a fun fact for everyone listening. 3 years is your limit. So if you've borrowed money from someone more than 3 years ago, in the eyes of the law, you no longer owe them that money, and vice versa, So is there a similar limitation for the CCMA for you to bring your dispute to them, or is it a free-for-all forever? How does that work?
Timeframes are very important when it comes to the CCMA. I think the first question to answer is, what dispute are you bringing forth? So in instances of unfair dismissals, you would have to bring it within 30 days of the dispute arising.
Okay.
Whereas with unfair discrimination, you have up until 6 months to lodge a complaint with the dismissal.
Yeah. Okay. So thank you so much for joining us today. As I said, we will be linking to all the CCMA information down below, and then we will also be including the contact information for our labour law department, because I think what people should bear in mind, although you can't have an attorney represent you at the CCMA, you could have an attorney advising you if you need that. I think that is something that we do see quite often, because although the CCMA is made for the people, it is still a legal process, and it might be difficult for some people to go through. So if you want to contact our offices, the information is down below. Also, if you have any questions you want us to address, remember to comment it. You can send us an email to the link in the description. And then, like and subscribe, and we'll see you guys next week.